Now, very humbly, I would like to invite Honorable Justice J.K. Maheshwari, sir.
न्यायमूर्ति जितेंद्र कुमार माहेश्वरी सुप्रीम कोर्ट के जज हैं। आपका जन्म 29 जून 1961 को मध्य प्रदेश के मुरैना जिले के जौरा कस्बे में हुआ। आपने 1982 में कला में स्नातक, 1985 में LLB और 1991 में LLM की डिग्री जीवाजी विश्वविद्यालय ग्वालियर से प्राप्त की। 22 नवंबर 1985 को मध्य प्रदेश राज्य बार काउंसिल में अधिवक्ता के रूप में नामांकित होकर सिविल, आपराधिक, संवैधानिक, सेवा और कर मामलों में वकालत की। आप 25 नवंबर 2005 को मध्य प्रदेश उच्च न्यायालय के अतिरिक्त न्यायाधीश नियुक्त हुए और 25 नवंबर 2008 को स्थायी न्यायाधीश बने। न्यायमूर्ति माहेश्वरी 7 अक्टूबर 2019 को नवगठित आंध्र प्रदेश उच्च न्यायालय के पहले मुख्य न्यायाधीश बने। 6 जनवरी 2021 को सिक्किम उच्च न्यायालय के मुख्य न्यायाधीश के रूप में आपने पदभार संभाला। 31 अगस्त 2021 को जस्टिस माहेश्वरी ने भारत के सर्वोच्च न्यायालय के न्यायाधीश के रूप में शपथ ली।
Namaskar, good evening. If we go on a theme of today, then this theme is legal education, training, bridging theory and practice. And the topic which is given to me is judicial oversight in legal education, ensuring quality, oversight of legal education, ensuring quality, ethics, leading to access to justice. Justice Louis Brandeis said that the greatest threat to liberty often comes in times of seeming benevolence. What is the purpose? Why these threats? How threats come for seeming benevolence? This is willingness and thought process of a man. What should be the thought process of a man? In the words of Justice Bhagwati, when we are in a legal system, what should be our thought process? Our thought process should be only the people themselves who must utilize law for the purpose of bringing justice at the doorstep of the large masses of the people of the country, if we are connected with legal education. Suppose this is a thought process and our thinking must be do better, what we cannot achieve. We can achieve everything, but it must be a part of our thought process. The topic has given to us judicial oversight to the education. If we go by that, first question arises in our mind, what is this judicial oversight? Is it something intrusion? It is an act of intrusion? If it is not, then what? I say its oversight must be only an investment for the judicial ascertainment of the judicial treatment. So this must be a thought process while we are there. Fortunately, I was a part of a judgment, Constitution Bench judgment, Bar Council of India versus Bonify Law College and others. 2023 SCC Online 130. If we go by this, then in this we recognize a larger issue with respect to education and what may be the standards of the education. Why it is so? Because the education standards were going to be declined. So a committee was formulated that was required to be looked into that appointment to examine the affiliation, recognition of law colleges, propose solutions, and frame guidelines for legal education and standards. And that report of the committee, then thereafter, suggestions of the amicus was brought into, Attorney General was a part of that probably. So what was the perspective brought in that judgment, bona fide? We thought at that time, while writing that judgment, that the judiciary in its role as a guardian to the rule of law holds a profound and multifaceted perspective on legal education. We understand that the strength of our judicial system hinges not merely on the letter of law, but on the caliber of those who interpret and apply it. So, what is coming? Apply it. Again, it is coming on ourselves. We envision a curriculum that what we have to do, how our thinking can develop in the colleges when we talk about legal education. Then first thing comes our study of legal education. On that, the curriculum must be that foster critical thinking, not the subject, statute, whatever it is. It must be critical thinking, analytical reasoning, and deep understanding of the socio-economic context. If we go on this perspective, we can have thought process. And until we have a thought process, being a person attached to the legal fraternity, friends, I thought our standard of the legal education cannot enhance. APJ Abdul Kalam in his speech said that the dream is not what you see while sleeping. It is something what does not let you sleep. So ourselves mind, when we have a critical thinking, when we have an analytical approach, when we have an understanding of socio-economic context, and that dream which is in our mind and not allowing to sleep us, that is a right way to proceed in the legal education, in particular in field of law. So we have to go accordingly. Second, practical legal training to the law students. That may be in different fields. We see in these days moot courts competitions are paramount, and every time we receive invitations to come in the moot court, either in inaugural session or valedictory. But what I perceive and thought, the problems which are being given in those moot court competitions should be practical problems which is surrounding to the issues coming to the litigation. But those are mostly, we have seen, related to the corporate laws, borrowed from somewhere. Those problems may not have any relevance, much more to those students who are contesting in that moot court competitions. And third, which is required in these days, use of technology. No doubt, in these days are not those in which we have studied. These days, in boys and girls are having technology savvy. They have to work. But as Professor Vajpayee has rightly said, that this era which is coming and the change is coming, going towards technological, and all way of education would be changed. That may be a possibility, but I have a word of caution to it. Artificial intelligence is artificial intelligence, not intelligence. It is not threat, it may be a challenge for everyone, because intelligence is born, artificial intelligence is man-made. So what we have to do is, artificial intelligence should be used for our upliftment, accepting it as a challenge and how we have to deal with. But it doesn't mean that is having everything and we have to rely upon. Again, I will refer Bonfire refers the very limited words. What is to be done is well equipped with the tools of law. What do you mean by tools of law with the ethics? We can say that those tools of law must always be in a direction what is right to do. But this tool of law should not be in a direction what you have a right to do. This, coming to the ethical issue, is ethics is something which you can read somewhere and do. I say this ethics come from your birth, from your basic nurturing when you start, from your training with whom you are training, you are learning. So this is a moral which we are learning. And if you have a moral right way, you know how ethically you must go and you should proceed in that. What is access to justice? Empowering everyone, individual, with respect to understanding their right to navigate the legal system and to seek redress for their grievances is access to justice. Not complete, but it would complete when that person who is citizen, who is hoping for that, who gets an order, who gets the real justice by way of judgments of the court. What should be the wisdom of everyone? This should be the wisdom that only gives access to justice to anyone. At the last, I will remind 2 lines of B.R. Ambedkar's speech, and that is everybody's, which I started, what we have to go ahead, do better, and it is always based on a man. So I remind his speech of the Constitutional Assembly. He said, however good a constitution may be, if those who were implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good. So friends, education, ethics, access to justice, all 3 things should be kept in one tandem, and keeping in one tandem, please introspect ourselves and how we have to act upon to achieve the justice, achieve the India glory. Thank you, Jai Hind. Thank you, Jai Hind.
Thank you so much.